Dismissed. Want to file application. Counsel for the in place for is granted 2 weeks, 3 weeks time to enable him file an application seeking service of notice on respondent through publication. Why 3 weeks? Because now vacation, right? You can have how much time? 3. Learned counsel for the appellant praise fund is granted 3 weeks time, 4 weeks time to enable her to comply with office objection. So the counsel is clear. Time. How much time? Learned counsel for the appellant praise fund is granted. Statement of assets in that date. Right. Further time. 4 weeks further time. Is granted to after vacation means you will comply it after vacation. You have furnished already. Then you should say. Now you have to take item 6. Third time it is being listed. Then what after vacation? Office objection also after vacation. You are going too far. Don't you realize? Too far. I mean, arguments understandable. For compliance of office objection, we have not dared to ask you a single question. But for that also you are seeking after vacation. So after vacation, you will comply with office objection. We will dismiss it today, your case. That you don't want to comply with office objections and you are praying that it be taken up after vacation. Prayer refused, appeal is rejected for dismissed. Too much. We are considerate to you. That doesn't mean that you should take undue advantage. Don't. Same order. 4 weeks time is granted. Further time is granted to comply with office objection. Memo filed on behalf of the appellant for acceptance of service of notice on accepted. Appeal is admitted. Mr. Appeal is admitted for hearing. None has, despite service of notice, none has appeared on behalf of respondent. What is there? No. Appeal is admitted for hearing. Office is directed to secure the record of the family court. You can have why 2 days, 4 weeks time now. This warrant is granted 4 weeks time, 4 weeks further time.
It is filed for maintenance by the appellant wife.
Which IA 1, 2 of 22?
2 of 21.
2 of 21. Yes. So, yes, you have filed. Yes, madam.
Is working as a case officer. Enjoying more than as per their own say salary slip. 77,000. I have to maintain my daughter.
Ready? Yes. So what? Yes.
I have to maintain my daughter also.
What is the age of daughter? Date of birth?
16 years. Used her first PUC. Regarding the SSC marks card along with the FOIA.
Year PUC, yeah. 16-year PUC second year.
For her.
What is the date of birth of the daughter? No idea.
Page 3.
No, but you will not tell us the date, right?
29/8/2006.
See everything, page 135 and this thing, but you will not tell. So please sit down, we will help ourselves.
29/8/2006.
If this is the attitude, then we have to go through it and we will pass an order. Sit up. Why to hear you? You are not appearing to assist us.
29/8/2006.
29, 6. What is name?
Rasmika.
E?
Rashmika.
Rashmika. And she is a student of second year PUC. Yes, what is your avocation? Madam? Advocate.
Assistant Director of Fisheries.
Assistant Director of
Fisheries.
Fisheries.
Sorry, factories.
Assistant Director Factories. So what is your salary? Approximately government servant, right?
My payslip is not
Government servant. What is approximately why? 63. Right? 60,000. And is there any maintenance awarded by family court? 10,000. That you are paying? Yes. When we ask you to argue, you don't argue. And we are interacting with other counsel, you interrupt. You prepare the case first. We are giving you time to prepare the case. First, prepare the case. You don't know the date of birth of your daughter. What? We have to pass an order. Therefore, we are interacting with her. We will hear you. You first prepare the case. Go through whatever you want to argue. So, granted, in this appeal, no maintenance. All right. So, but in this proceeding under section 24, interim maintenance, she is entitled. So then, so 63,000. Your daughter is a student of second year PUC, correct? That you have to do. I mean, there is nothing unusual about it. Nobody. Like supposing if you are having a daughter, you will pay the school fee. There's nothing like not paying. And you have to maintain her also, right? She's entitled. That is what should be the quantum. So your parents are dependent on you, right? So you have taken what EMIs you are paying, everything loans, 40,000 you are paying EMI and hardly surviving on 20,000 like that. Oh, house. What is the EMI? So at least, madam, by any standards, any modest standards, at least 1/3 of your income you should pay as maintenance. Would appreciate, but see, he has no instructions, he is not prepared the case. What can be done? So we are deciding this IA. So we'll grant 20,000, 20 you
Both
second year PUC.
you are not paid from this order. 2000. That there are onwards we are not paid anything. That is for our arrears, no?
We will grant it from
These
the
2
date
years
of
also.
application. Yes. Okay. Oh, we wish that we had judges like us, so we would have never ourselves become judges. Do the homework, write an order, do everything, read everything. At the end of it, that's all. I wish we had judges like that. We have practiced before judges who did not even spare us when the case was listed for office objections. They used to ask, what is the case matter on merits? Forget about office objections. Today, if we ask you this question, it's a crime. That is the difference in past 25 years. That is the deterioration. Third on, mark the present. Third on IA members. 421. An application seeking ad interim maintenance. Learned counsel for the we have heard learned counsel for the party. The marriage between the parties was admittedly performed on 1/6/2005 and from the wedlock, a daughter, namely T. Rashmika, was born on 29/8/2006, who is a student, second year PUC, and is in the custody of the appellant. It is also not in dispute that the appellant and the daughter, namely, are residing and in an accommodation which belongs to the respondent. It is also not in dispute that respondent is as assistant director within bracket factories and is drawing a monthly salary of ₹63,000. Full stop. Taking with paragraph, the respondent is under a statutory obligation to maintain the appellant and his daughter. Full stop. Therefore, taking into account the status of the parties as well as the salary of the respondent, it is directed that respondent shall pay a sum of ₹20,000 per month to the 20,000 per month to the appellant as well as her daughter from the date of filing of the application, namely IA number 2 of 21. Accordingly, IA 2 of 21 is this. You have not said anything. So you want to how much time? So patience so and so that IA is allowed. Then how much time matters? Arrears 3 months. 3 months. You pay the arrears in 2 installments, right? 2 installments, 2 months and thereafter. Then the consequences will ensue, madam. Not sufficient means you are drawing the salary of 63,000, madam. Then, no, when is the date of the application? No, application. We have said from the date of application. Then you can't get away like this. You file an application.
2 years also you have saved. No, from the date of judgment, you are not paid till this because it is stopped at that time. This
we have not
order,
fixed the time limit. You should not insist. We have not fixed the time limit. But you should pay. Sooner the better. Yes. Sooner. What EBS purpose?
Custody. That's the same. Why?
Please don't show us WhatsApp message. Don't show us WhatsApp message. If it's a privileged communication between you and your client, we are not interested. What is, yes,
Not, no, we, in past 3 days, the child is with me.
Huh?
It is child is with me, now for vacation is come down to Bangalore.
Ah.
He is with me now.
Yeah.
Now, the party is concerned, now, then we have got something, single thing.
what objection you want to file? Oh, petition.
This is the case. Assist. Why? Change it. Now he's saying boy is with you.
How is it, you know?
He has come. See, you allowed a big boy. He was in residential school, no?
What? No, we have interacted with the children. We know that both of them are in boarding school. So what?
Vacation.
Ah.
No, he wanted to join the father, that's why the telephone.
Mother has joined the father. Very good. Mother,
Join the father. 3 days is with me.
son.
Why?
Son has joined the father. So let them then file objections.
She's undergoing some treatment. Other girl is a daughter.
That your person is, your client is suffering from, the allegation is from some mental disorder, right? It's that case. No, that is the allegation. We don't know. We are not doctors, right? We are not. So that is that case. So, Mr. When will you file objection? Learned counsel for the respondent. Learned counsel for respondent is granted a week's time to enable him to file objections. You can move in the vacation if you want.
Child is with him only, sir. Now boy has come.
No, he's fighting for daughter.
The daughter is-
You are fighting for daughter.
daughter is
No, so if the child is with
Then
you,
we
then
can
the
close
end of
this.
the matter.
Can close.
Why?
Because of vacation is with you. Can't we go back to
So then how EBS corpus then? At end of the matter.
Then you go to family court. and
Family court file an application for,
I will only request
then this is EBS corpus.
Can we close?
So that the child is in your custody. The end of
And
the
when
matter.
child has come to
Yeah, you file the petition seeking this thing, your appointment as guardian. Yes. Learned counsel for the,
child goes to boarding school. And I could have access to the child there.
this not the
That you get
EBS
that.
corpus petition is not a petition directing visitation rights and please understand the scope. We are liberal. This all should not be entertained basically. You file a petition before family court, seek visitation rights, do whatever. This petition has been
Spending.
pending. Don't know. This petition has been filed seeking a direction for production of the minor child, namely Sai Prasad, before this court. Paragraph: learned counsel for the petitioner submits that on account of summer vacation of Master Sai Prasad, he has come to stay with the petitioner during the summer vacation. Full stop. In view of the aforesaid submission is placed on record, we do not find any ground to this petition. Accordingly, the same is disposed of with the liberty to the petitioner to take recourse to such remedy as may be available to him in law with regard to custody of the minor. We are all, how many EPS costs? We are already dealing with one in those partner. Tomorrow. Tomorrow. Not there. Why push it to last day? Then you can move in vacation. Learned counsel, learned count, Mr. So and so, learned SPP. place for short accommodation to enable him to produce the record pertaining to detention of the petitioner list in the next week. Right?
Take my chances on 20%. Possible.
21st, bench is only till 1:30. And you please do not expect us to carry some baggage during vacation. I have never done it. Well,
The police.
yes, Mr. So it's a serious issue. Respondent number. Yeah, sent email. Respondent number. What email? Is this? Huh? So we hope that she doesn't become a person like the one who is absconding in Punjab and 18,000 odd police force is unable to find a crowd. No, not. Yeah, what this is the email we have received. What is this email? Not appearing and sending email. We have to
She
go.
difficult in the execution saying that I know the date and execution.
No, that was, but we really like that idea. That when somebody comes, I am suffering from COVID, don't touch me. Very good, innovative idea. Is this?
Yes.
But he must be watching on us. Maybe that.
We'll ask the commissioner. of police.
No, Mr. This is a
Police has
serious
to clear
issue.
out.
Please appreciate the safety of minor daughter in our. We have every reason to believe that it is in danger. We have heard him at length, the case at length. Safety of minor daughter is in danger. And she has lost it. No, see the audacity, despite having lost, the order passed by the division bench has been upheld by Supreme Court, and despite that, she is not handed over. See the audacity, how she is taking the system for a ride. No, you arrest whatever. Produce. What did we do? All right, mark the presence. Office is directed to prepare a summons and learned SPP2 and to hand over the same to SPP2. Learned SPP2 shall ensure that the aforesaid summons, aforesaid notice is served on respondent number 3 through Commissioner of Police. Correct? What is this? Yes, I am aware. Being listed for hearing on 19/4.
The execution she sent on email saying that I'm aware it's on 17th, my counsel will come in 5 o'clock, nobody cares. I don't know whether she sent
I have
it.
the right to hand over this copy. These people, sir.
Well,
Let them.
So when the
Otherwise,
who has
the
given you,
commissioner
Mr.? Who has given it to you? Acha. Then right before that you write when the case was filed. From perusal of the record, it appears that that you have not been able to serve hand summons, right? That's right. Her name, yes. So the counsel for the petitioner has been unable to serve hand summons to respondent number 3. The matter is listed for. The note has been put up by the office that service of notice on respondent number 3 is awaited. The court officer has handed over an email which is sent by respondent number 3 to the registrar judicial. In the email, it is clearly stated that respondent number 3 is aware that the matter is listed today. before this court. In the email, a prayer has been made to engage a counsel and to avail of the legal remedies. Full stop. Time is granted, full stop. Then this thing, office is directed to so and so and directed to and let the summons be handed over to what is this thing? DIG and whatever DGP, right? Commissioner of Police, and what date?
27th, Thursday next week.
List on 27th April 23. On the appropriate date, appropriate order shall be passed. Still, I mean, you have to deal. Don't take it to be the safety of a girl child is, and it is unfortunate. It is so, despite the fact that she is in the custody of mother. We are. No, you have to. No, you have to serve it by all means. Okay. Yeah.
And
6 office objections. Well, what your daughter is missing? 17 years.
lawful custody, she went to college. Parents are fearing, and she also called the parent, but she is also worried in the phone also. They're fearing some unlawful people are taken. That's what it is. Also, please.
Find out about her boyfriends. That we can ask him to welcome his son-in-law. That you must be knowing, right? Very often our experience, I mean, very often like the girls aged about 16, 17 years, they go missing and they come with their husband. She will come and tell that I am married. He strictly doesn't go. We are, since your daughter is involved, I mean, you are a father, that's why we are entertaining. But the legally speaking and strictly speaking, writ of habeas corpus does not lie. If a person is missing, you have to take recourse to the remedy under Code of. But since I mean, where will he go? He is the father of, and also minor.
No, that
Find
is
out.
on maintenance. Maintenance is one, but you also
You are
required
a
to do.
welfare state. You
As a
have to
citizen, you are
ensure
required to
this
act.
thing. Welfare of your citizens, right? Where will he go? What can?
14th April, FIR is registered. Nothing is done. You are certain from.
What have you done? 14th April.
So,
Next, Learned Counsel. So office objections during
In 2 days.
Learned Counsel for the petitioner undertakes comply with office objections. Within 2 days. Notice on behalf of respondent is accepted by Learned SPP. Office is directed to reflect his name. Learned Counsel, Learned SPP prays for a short accommodation to enable him to apprise the status of the investigation pursuant to the first information report which was lost on 14/4/2023, as well as to take steps to trace out the missing daughter of the petitioner. Well, list on 27th April 23.
No. It's a request for me now. What is happening in the case? What is there?
Non-compliance.
There are some office objections. Right. So not just give me just 1 minute. I'll explain what the problem not is. But these review petitioners were the original petitioners. But
What about office objections?
they may not be necessary, not if the lordship should permit me to make one submission. The main contesting respondent lord is the government and the MUDA. They are not. In this
You are appealing from the.
that is MUDA. One is state, 2 is 5 is MUDA. There are only others respondents are, they were petitioners who did not join in the review, so pro forma made them respondents. But the point to be this, I only want one observation from the court. That's all the submission that I'm making. So can you see page 96? Only submission I'm making this note. If I can just take 1 minute and explain the problem. These petitioners not are unauthorized occupants. Land was acquired. Those acquisition proceedings were challenged not twice. It went and up and down the judicial ladder. Finally, my lord, at page 96, lord, the learned single judge, when I filed the writ petition for regularization, the learned judge said you're unauthorized occupant, we can't give it. In appeal, my lord, your lordship made this observation at page 96. Page 96 of the review petition, para number 4 of the order.
So previously also you had filed a petition.
There was not, we are the writ petitioners, no.
Ah.
We were the writ petitioners. Admitted
Earlier,
position,
which petition you had filed?
position is, I was an unauthorized occupant. The land was acquired for the purpose of Mudam law. That acquisition was challenged. No, the challenge would not have failed. And at the time, your lordship dismissed, affirmed the order of the land single judge not held. Since I am an unauthorized occupant, I have no legal right. That was in appeal. Your lordship not affirmed it. But by doing so, not at page 96, your lordship made one observation.
Since it is for office objections, we have not gone through.
I am sorry, Lord. I apologize. No. I'm asking for only one observation. If your lordship could see page 96, para 4 of your lordship's order.
This is single bench.
Single judge order.
No.
Oh,
Division
this is
bench order.
single- No. Single judge.
Single
Court
judge,
order is
that's what we are seeing.
a- Yes.
Your lordship's order, Lord,
We page 68.
begins at page 37.
Oh,
It's a very long-
See,
The
right.
order begins at Annexure A, page 37.
Sorry.
The review, Lord, Annexure C is the order of the learned single judge. Annexure, this was the order, Annexure C, page 68, was the order of the learned single judge, which was impugned before your lordship's in the writ appeal.
Ah.
I'm only drawing your lordship kind attention to the order passed by your lordships in the division bench.
Where?
That starts at page 37, Annexure A. It's a very long cost title.
That we are seeing.
Yes, kindly go to page 63, internal page 27 of that order.
Ah.
Your lordship made this observation.
Ah.
You have heard, there is the order, is evidence that the applicants are seeking regularization is subject matter of acquisition proceedings, which is pending before the division bench of this court in appeal number so and so. Then a single judge has concluded that since land in respect to which appellants are seeking regularization is subject matter of acquisition, therefore the application seeking regularization cannot be entertained. Now, on the same day as your lordship passed this order, your lordships heard writ appeal 437 and dismissed it. That order is available, my lord, at page 98. Both were
Effect of dismissal of that appeal.
no, my lord, in the dismissal of the appeal at page 98, your lordships, my lord, affirmed the acquisition. The landowner had challenged it. This honorable court, my lord, said no, acquisition is upheld. Now, my lord, the only submission that I am making, my lord, is that there has been a series of representations given. If your lordship could please see, my lord, a development which has happened after the order, my lord, I filed a statement of facts. There is a resolution passed by Muda based on a government directive. My only request, my lord, is if your lordship could observe that these orders don't come in the way of their considering. That's all.
Which resolution?
Can you not see? I filed a statement of fact dated 17/4/23. In that, my lord, at page 11 is the resolution of Muda. At page 14, may read the middle of page 14. On 11/7,
This is dated 3/4.
this resolution, my lord, is 21/3/23. 21st March 23. That is after your lordship's order. My lord. Now, if I may read from the middle of page 14. On 11/7/97, the Urban Development Authority Department, that is of the government, directed the authority to regularize the sites in the said layout and allot sites in survey number of so and so to members of the Sangha by imposing some conditions. The conditions are I'll just skip over that. Please now go to page 16. The decision of Muda now, last penultimate para in page 16. Under the facts mentioned above, the subject regarding compliance of order dated so and so for Chamundeshwari is placed in the meeting resolution. Extensive discussion held. Commissioner explained the entire details of the case to the board. The said case in the court for several years. At present, the court order dated 27/2/23 in writ appeal is in favor of authority. Hence, for implementation of government order, Commissioner is informed to bring it to the notice of government to take suitable action. All that I am requesting, Lord, is that though your Lordship, Lord, have said affirm the order of the learned single judge, if they can consider it, because there is already a government direction, Lord, what happened was this large extent of land, Lord, has been in our occupation. Many of us have built homes. They're all senior citizens between the age of 65 and 85. I'm asking action. I'm only saying, my Lord, that this, your Lordship order may not come in the way of the government and the Buddha considering it. That's all. And all conditions they impose, Lord, I have no objection with them. Otherwise, they think that because of your Lordship order, they can't do anything.
You are seeking a clarification.
I'm only seeking, Lord, one observation that this order will not come in the way of the government and the Buddha taking action according to law.
In accordance with, they are granted the liberty to take action in accordance with the resolution, whatever.
That's
That's all.
all.
What do you say? Resolution passed on 21st March. So to regularize the possession.
Cannot be regularization, but it may be allotment kind of.
By a process of
Because regularization, we have said it
because
cannot be
now
done.
only, Lord,
They wanted,
your
you
Lordship,
can say, sir, saying that if they wanted to.
by your
It will
allot.
be open a lot.
Allot.
by your
Yes,
Lordship's order in the writ appeal affirming the acquisition, the matter has no assumed finality so far as acquisition is concerned. So it will be a
It's a
process of
allotment
allotment.
only.
We
It's
will
as good
say
as
that
allotment.
in terms of resolution dated 21st March 2023, it will be open for them to take steps
Right.
for allotment of sites subject to such that, yes, what do you say? No, but now what he says that on the same day, the acquisition has been upheld, so land vests in the Buddha, and they have
They
passed
have
the
to-
resolution. Take a call, what to
No legal impediment, sir.
Ah.
There's no legal impediment.
yes, that clarification.
They have agreed what we will do. Board has agreed.
You are agreeing, right? We will
They
record.
pass the resolution.
You are not official. Fine. What are the now office objections?
To respondents, number 19. Cannot be necessary because
Yeah, the-
8 to 18
Landowners, sir.
were the my petitioners. Since some of them have died, their LRs are not available, so I made them pro forma respondent.
8 to
8 to 18B. And 19 was the original writ petitioners.
so they are represented.
Yes, so far as he is concerned, it has become final with your Lordship. Others are state only. Except for respondent 5, who is a Buddha.
For a hearing for Mr.
Right.
Here, find out for whom is the. Additional government advocate, learned additional government advocate for respondents. 1, 2, 4. And what gets to appear for respondent?
5, 6, 7. 5 to 7.
Commissioner Masood Nakar.
She is
Huh?
Muda.
Oh,
5.
So like 5 and 7, right? No,
7
Oh.
also, no?
7 you will appear, Mr.
Planning authority.
7 is
Planning.
Mudam, part of
Modem,
Mudam.
part of-
Part of five.
So you are, what's your name?
What's your
What
name? Siddharth Singh.
Learned Council correspondent number 5. Line below, taking into account the nature of what order this court proposes to pass, it is not delete that. After hearing learned senior counsel for the petitioner, office objections are ignored. Heard on IA 1 of 23 for the reasons assigned in the application, duly supported by an affidavit. Requirement of production of translated copies of documents is dispensed with. In the result, IA 1 of 23 is allowed. That's right. Taking into account the order, taking into account the nature of order which this court proposes to pass, it is not necessary to issue notice to remaining respondents. This petition has been filed seeking review of the judgment dated 27th February 2023, passed by this court in the by which the by the appellants was dismissed and the order which was affirmed. Paragraph. Facts giving rise to filing of this review petition. It is stated that appellants as well as some of the respondents were in unauthorized occupation of the land in question. The appellants as well as some of the respondents submitted an application to Mysore Development Authority, Urban Development Authority, seeking regularization of the land which was at occupation. The aforesaid application was rejected by Mysore Urban Development Authority by an order dated 25/10/2014. The appellants as well as some of the respondents in this review petition challenged the validity of the aforesaid endorsement in WP number 1513-662/2015, which was dismissed by learned single judge by an order dated 6/12/2016. Paragraph. This court by judgment dated 27th February 2023, passed in WA 5681/2017, affirmed the order passed by learned single judge. Paragraph. Thereafter, full stop. Affirmed the order passed by the learned single judge. Full stop. In para 3 of the judgment, a division bench of this court is that the land in respect of which the appellants are seeking regularization is subject matter of acquisition proceeding, which is pending before a division bench of this court, namely WA number 437/2014. Paragraph. On the same day, that is what we
27.
27 February 23, by an order by 27 February 2023, dismissed the appeal, namely WA number 437/2014, and the acquisition proceeding initiated in favor of Mysore Urban Development Authority were upheld. Full stop. It appears that subsequent to the order, subsequent to the judgment dated 27 February 2023, not it appears. Really, the subsequent to judgment after the judgment date 27 February 2023, passed in WA number 5681/2017, and after decision of WA 437/2014, Mysore Urban Development Authority passed a resolution on 21/3/2023, and and took a decision to allot the sites in survey numbers of Latka Galli village to the appellants to the allottees to the appellants as well as to the writ petitioners. The writ petitioners in WP number 5153 of
2015.
of what it dash 562 of 2015 full stop, by imposing some conditions, full stop, on account of paragraph. Learned senior counsel for the petitioner submits that learned review petitioners submits that the review petitioners are not seeking review of the judgment dated so and so 27th February 2023 passed by this court in WA 5681/2017, but are only seeking a liberty to Mysore Urban Development Authority to act in terms of the resolution dated 21/3/2023 passed by. The aforesaid prayer has not been opposed by learned additional government advocate as well as learned counsel for the Mysore Urban Development Authority. Paragraph. In view of subsequent events which have taken place after the judgment dated 27th February 2023, we direct that notwithstanding the judgment dated 27th February 2023 passed by this court in WA number 5681/2017, it would be open to Mysore Urban Development Authority to take an action for regularization, take an action for allotment of the sites in favor of petitioners in WP number so and so to whatever so and so of whatever WP number.
You should find it at Annexure C, page 68, 51523.
68.
68.
Yes. WP number 51523-662/2015. Subject to what have you written? So and so subject to such conditions as may deem fit. A comma in terms of resolution. It is open. We have already said resolution. Open to it. That's it. Right.
We are all from 1980 onwards.
That will not.
At this stage, he will. Wow, how much time? You tell us. At this stage, learned counsel for Mysore Urban Development Authority submits that suitable action for allotment of the sites shall be taken in terms of resolution dated 21/3/2023 within a period of 8 weeks from today. Line below, the aforesaid extent, the judgment dated 27th February 2023 passed in WA 5681/2017 is clarified. Accordingly, review petition. Number 15. Okay. Oh. You have sent him away. Huh? You have sent him away. Oh, he has come. Hey, he is appearing with you. Yes. What non-compliance of yes, to comply with office objection, right? Learned counsel for the appellant. So let office objections be complied with within a period of 2 weeks.
Yes.
Huh? One file, that's all right, passport. Yes, madam. No, so when it is listed, you will appear and be ready. And you will not seek an adjournment. No, we are asking you, we are not concerned who is the district. We are asking you, supposing if we allow the application and grant a date, on that day, will you remain present and will you argue the case and not seek an adjournment? That's what, because we have seen people that they get the case listed on a mention memo and don't appear. That's why we are asking. We have no problem. All applications in this court for early hearing are granted. But we find that the counsel who seek early hearing, they are absent. That's why we ask. Not for the appellate. So and so learned counsel for respondent. Heard on IA 1 of 23, an application seeking early hearing. For the reasons assigned in the application, comma, duty. Reasons assigned in the application, as well as taking into account the fact that appeal is pending. As well, which section? PH. No marriage act.
21A.
21. As well as
Six.
taking into account the amended content in, Mr. You keep this ready, and you read it during summer
21.
vacation. Huh?
Yes.
You should, they don't.
21 B3. 21
B3. So you should be ready. They are not supposed to tell us, but you should be ready. You are an officer of the court. That's why you are called court officer. Correct? Huh? You can't behave like that and not be like an officer of the court. You are court officer and you have to be an officer of the court. Correct?
Retirement also you can make use of that. You can expertise
As well as in view of content in section 21B of the Hindu Marriage Act, IA is allowed. Let the appeal to this for final hearing on 6th of notice of IA 1 of 23 and 1 of 21. To respondent, office is directed to secure the record of the family court. Order. Same order. On both IAs and record. Same order.
IA is filed by.
Yes.
IA is filed by NCA.
Yes, but yes. Yes, sir. Correct.
But on 14th, my lords, itself, the application, my lords, is dated 14. On 14th, my lords, the president of the board has withdrawn, my lords, the order setting up, holding the teachers to be ineligible. For all the teachers, there is an order of communication by the authority itself saying you withdrawn your order.
We are not going into merits. It is not another round of litigation.
The
We will argue.
only reason why I pointed out,
We will argue for 3 hours, not
the
like.
only reason why I pointed out, my lords, was
We are asking you, do you have any objection? to-
by my lords, 2 weeks, 4 weeks overall, my lords, that is from the date of your order.
So what, which appeal is, your appeal shall be decided by the commission within a period of 4 weeks.
That is imposition of penalty.
So you want In addition, board is directed to decide the issue pertaining to grant of additional within outer limit of 2 weeks from today. So that you want after decision of the appeal. Right.
2 weeks, my lords, would entail then the whole, my lords, the urgency that we pointed out, my lords, the permission will be withheld, my lord, because they have imposed the penalty.
No, this appeal will be decided, Mr. within 4 weeks.
Two different issues, my lords, that is penalty, my lords, this is regarding permission of the institute.
Permission of the appellate authority, she says that appellate authority shall decide the appeal on or before 29th April 23. She doesn't want any change in that. What she says is that this, we have said that direction give this thing a suggestion that the process can simultaneously go. What she says that 2 weeks after the decision in the appeal.
Would your lordships kindly restrict it to 1 week, my lords, because the decision is.
Very reasonable.
If it all gets changed,
1 week, madam. What is there? If you, like, you will have already, fine. All right. No, board is directed additional permission. So you will have a decision in the appeal on that basis. You decide after all, it's all whole thing is time bound, right?
last week, I pointed out,
Right.
the order is withdrawn.
Right. Third, mark the presence. What is the IA? Third on IA number. 4 of 23. An application seeking modification of the order dated 29th March 2023. Passed in WP number 5205 bar 2023. After hearing learned counsel for the parties, it is directed that it is clarified that the appeals referred by the college against order dated 1/2/2023 shall be decided by the commission afresh after affording an opportunity of hearing to the college within a period of 4 weeks from the date of order dated 29th March 2023. Hereafter, the board shall decide the issue pertaining to grant of additional permission to the college
Condition.
within, sorry, this is conditional permission. Decided, is the, directed to decide the issue pertaining to grant of conditional permission to the college within an outer limit of 1 week, right? To the aforesaid line below, to the aforesaid extent order dated 29th March 2023. In WP 5205 bar 23 is modified. Accordingly, IA is 1 week thereafter. We have said thereafter within 1 week. That additional.
That is correct, sir.
That's conditional, right?
Then subsequently modified.
She may see it, it's not there.
Yes,
That's why
yes.
I'm telling you. Like additional, that is conditions. It is admitted for hearing. Issue notice. Record. Here counsel is coming for- Then you will appear. Yeah. They also don't say your junior. Where is your junior? How many juniors you have, Mr.? Like, how many colleagues? 5 or 7. Where are they? Call him next to you. Where is call him?
You go back and in the same quota.
There to appear in an appeal under section 19 to oppose. It will be admitted.
Admission.
At least for these cases, no, why we were wondering that even for admission of senior counsel appeared. So we were saying that at least for these cases, let your juniors appear, let them give an opportunity, Mr. And this is obviously innocuous order. It has to be admitted. The law says an appeal shall lie. We cannot dismiss the appeal. So at least for these cases, permit your juniors to appear. That's what we are discussing. That even for
Applies to
admission,
Ravindra also.
senior counsel is appearing admission. Just now, previous case you have seen, senior counsel for admission. So give your colleagues an opportunity in these cases. How many colleagues do you have? And where are they?
On Friday.
Trial court. In charge of trial court.
You should have gone to trial court to argue a civil suit, and then you should have sent them here. Huh? Correct. At least in MFA. Of the presence appeal is admitted for hearing. Record is there. Huh? Record. Record. 22 also record, 23 also record.
24, everyone among here.
Right. No, have you filed it?
Objections.
Nothing survives practically. We can, you want to keep it pending, that's all right, but you understand, right? If after the period of limitation, after 1 year and 4 months, if he has married and he has a child from the second marriage, then what is there to contest? Except for the litigation, except for saying that my appeal is pending before High Court and judges are not hearing it, and it is every time it is adjourned. That's how you tell the clients. I don't know, judges were allowed with dismissing the appeal with great difficulty. I got it adjourned. You don't know what difficulty, what pains I took get it adjourned. And the court is against you. If you want, I will get the case listed, and if appeal is dismissed, don't blame me. Right? Correct? No, this is what our 20 years experience, that side tells us, like, what you want to verify. Learned counsel for respondents submits that after the expiry of the period of limitation, respondent has remarried and has a child from the second marriage. Attention of this court has been invited to the certificate of registration of Hindu marriage, dated 8th of certificate of registration of marriage. Certificate of registration of marriage dated 8th of April 2021, as well as birth certificate dated 3/2/2020. Right? 3/2. Already we have said certificate dated 3/2/2020. There is nothing, Mr. There's nothing to doubt until unless you say it is forced. You have opposed submission. Learned counsel for the applicant prays for short accommodation to enable him to seek instruction. List after doing some more. We don't, you would be, Mr. Advise your client not to prosecute. This is a fait accompli situation. Whatever, claim maintenance, do whatever. Don't prosecute, there's no point. Even if you succeed, you don't get anything. This obviously will be a factor for us to reckon with that. We will have to take into account this subsequently. It's not that within statutory period, beyond this thing, beyond limitation, you have got that. Please think about it.
But 25, she will preserve, Yadinova.
Counsel for the applicant. Praise for adjournment on the ground that how do we make out? Now we have developed this art of reading your mind also. What ground? Senior counsel is out of station, not available. You want to engage senior counsel. Your colleague, then he has to appear.
Yes, your lordship, he didn't appear today. So waiting for a call.
Why he is not on account of personal difficulty?
He since he last.
Or it's for the appellant submits that the arguing counsel, Mr. Putin Prasad, is not available. We don't want to write that he has gone to Delhi, not available, out of station. The counsel therefore prays for adjournment. This is all covered, madam. Then why should you seek an adjournment? And our order has been upheld by Supreme Court. It's
I understand.
So you understand that it is covered by division bench of this court. Same this thing we of course with different combination, and that order has been upheld by Honorable Supreme Court. So what happens? It binds us. So even if Mr. Nisit Prasad goes to London or Delhi or Mumbai, the Article 141 remains. And we are sure after summer vacation, it will not be annulled from or deleted from the Constitution. So that result, no, you understand that the result is same. At least in these cases, when you know, then you should have asked your senior. If the court asks me that it is covered and it has been upheld by Supreme Court, what should I answer? You should have asked him. You are saying sorry. Why you should be sorry? You have not done any offense. Why should you be sorry? List after summer vacation. Which SLP Mr. produced that order? It may not be to your liking, but the fact remains that it has been upheld. You have also filed SLP. You should seek adjournment instead of that. We want to find out what has happened. Huh? What SLP? What happened to your SLP? Dismissed. Oh,
That also
then
give us copy.
give a copy. So madam, not
Yes.
one order, two
Yes.
orders. Their SLP has also been dismissed.
Number also. You will
What
take
it? The case of fate of your case is sealed. Nobody can help you. No. Huh?
Are you on the next?
No question. That's what you are covered. After publication of preliminary notification and final notification, you have not taken any steps to pass an award. This court has held that even though no period of limitation is prescribed, these steps have to be taken within reasonable time. If it is not done, then it is violative of not only the constitutional right of a person to hold the property, and we have quashed the process. So that order has been upheld by Supreme Court. And we had decided against them. They had also filed SLP. It has also been dismissed. That's what he's telling. Produce that order. Next it.
I beg to appear for appellant, my lord.
Appeal is admitted for parties. Appeal is admitted for record peruse. Appeal is admitted for hearing. What is record is not there. There. Admitted. No adjournment. No passport. What is it?
Section 9.
Vice petition under section 9 allowed,
Petition 13 dismissed.
but on the question of what's your name? At least you can tell your name. Learned counsel for the appellant heard on the question of admission. Appeal is admitted for hearing. This office is directed to secure the records of the family court. Which judgment you have filed? See, 44. Dismissed. MC 44. Ah, yes. In the absence of the The petition filed by the appellant under section 13 of the Hindu Marriage Act has been discussed. Therefore, there is no executable decree. The question of paying the same does not arise. Accordingly, IA 1 of 23 is hearing to notice record. The order. Same order. Right. Where is your colleague? Huh? You are all alone, single man army. What?
He's alone.
Admit. We should notice record. At least in these cases, your colleague should appear.
Stay.
So restitution, execution proceeding, fine. You are wife or husband. Then nothing is done. Admit, issue notice, record, issue notice on IA 1 of 23. Nothing, vacation, nothing else. List for analogous hearing along with MFA number 2534 bar 23. He is performing the duties of really the court officer. He is telling us it should be heard along with 30 days. So you should say no. He is telling us that it should be heard. Super. Seniority is over. No. Both of you in different channels. There can be no question of seniority. Not safe. Yes.
Objections not filed.
This is the only case.
Objections filed.
Objections.
Objection there.
Let them file objections. Learned counsel for respondents. Learned counsel for respondents pray for and are granted 4 weeks time to enable them to file objections. List immediately after ensuing summer vacation. Got it? List on, we will give a date to you. 24th April. 26th. 24th May. Please. For the appellate, even when matters become none for parties. Awaiting appearance, hearing with paper list after summary. Hey, where is Mr. Javli gone? He appeared yesterday. All right. Yes. All right, that's a good. Yes. Yes. So you don't know what he has argued.
His main contributions will take
No, two things. No, you don't know that. Again, yesterday we told Mr. Javli that this is what his submission. Again, we will have to tell you because we don't know what he has argued. First thing is that it says order of remand being perceived, extension of remand being perceived without jurisdiction in view of law laid down in para 61 in Gautam Navlakha petition maintained. Second submission is the sessions court at Mangaluru alone had jurisdiction because the NIA court in Bangalore, special court, is not a court notified under section 22(1) of the NIA Act, and therefore this thing, order of extension of remand and the rejection of default bail. That order, if any orders on that application could have been passed by virtue of section 22(3) of the NIA Act only by the Court of Session at Mangalore. Correct? These are the two submissions. And he relies on this thing, a division bench of Bombay Heights. Yes. One query, whether this provisions of NIA Act apply. No, under which provision then which court is competent? Yes. No, so you say, just a minute. Fine. So you say provisions of the UAPA Act apply and not NIA Act. Then 43D2 what? Yes, what? Which provision, Mister? What on this? What 43D? You have the act. Please read that.
Right. Good evening.
No. So you have to tell us prima facie that NIA court at Bangalore had jurisdiction to deal with an offence which was committed in Mangalore. Hearing of this matter, serious come. Now he so far as of the scholarship which has been detained, that cannot be considered areas of only part of sequel. So that is exactly what this Supreme Court has said in Gautam Navalika's case. Please read that. Not maintainability on what grounds? Because we should be clear on facts. You have not told us that, see, Mr. We are simple question. We are again repeating. We told you, I mean, though it was none of our job, we have told you what is argued. We told another council today, we have repeated, it's none of our job. You are not understanding this very probably. We are asking you prima facie show us how the court, NIA court in Bangalore had jurisdiction or semblance of jurisdiction to deal with the application for extension of remand and the passing an order on default bail. Please tell us, prima facie. How it had jurisdiction. The whole this thing is, he was produced before the magistrate Mangaluru. His submission is that the magistrate Mangaluru ought to have this thing remitted the matter to the Court of Session in Mangalore. Because under section 22(3) of the NIA Act, the Court of Session in Mangalore alone has jurisdiction. Because under 22(1), state government has not issued any notification constituting the courts. So that's why we asked you the first question, whether NIA Act applies. You said UAPA Act applies. Then you have referred to 43D2 without reading it. Then you are saying Gautam Naulakha is like this. What should we make out of your submission?
Exactly what we have.
This is no. There's no question of being busy, Mr. Our latitude, Mr. Our latitude should not be taken undue advantage. You have repeatedly sought adjournment in this case. Yesterday, this Mr. Javli was here. He heard the argument. He had no idea about the case. We said he was in a hurry to conclude. We told him we told him that don't do like this. Please go through the judgment cited by him and then argue. Then he said, all right, tomorrow I will argue. And then today you have come and you are saying the same thing. Not prepared means what? So you are arguing the case and you are saying I'm not prepared. No. It's the duty of the court. We told your colleague, Mr. Javli, yesterday, these are the two submissions made. And you say that it is not made known to me. Shall we come to your residence and brief you? No, this is not fair. At least all times, Mr. Irrespective of the result of the litigation, all times you owe a duty to be fair to the court. If you don't have an answer, say so, that I can't say that how it has jurisdiction. Say so. You can argue that this NIA Act does not apply. We will appreciate. You show that how UAPA Act applies and which court under UAPA Act had jurisdiction to deal with the prayer for default bail and all that. We can understand. This you can't say that I was not told. Who will tell you? He was present. You were there yesterday. Yes. Yes, Mr. Amicus, you were yesterday present. Why you did not inform me?
Another colleague of SCGP was there. Another colleague along with the SPP. No. Yes, I only wanted to conclude, but we have space for pose specific questions, sir.
You note down, Mr. These are the answers we are looking for. And if you don't give the answer, you know what is the order which will be passed. Serious matter. So you should be equally serious, Mr. Except for seeking adjournment, you have not done anything.
He was there.
Yes, I that tomorrow it will not be adjourned, Mr. This is unfair. This is unfair. Yes, tomorrow. Further hearing same time. No, not 2:30. Here only. Not 2:30. Why? No. It will be called whenever it is called. It is the same time it will be called, whatever tomorrow.
Because it's small point there. Only one, that is only one ground that has happened.
So we are under an obligation to inform him what have you argued. Thereafter, until unless he is informed, how can he argue? He told us that nobody informed me. So we should go in the evening to his office, brief him, then he will prepare. Perhaps indicate how to find out what to prepare. We don't know this. We have understood your case. It is for him to explain. If he is not able to explain, the result is a foregone conclusion. He understands. It will have a far-reaching impact. That's why we are granting indulgence, because he has no idea what you have argued. He was not present when you argued. He doesn't know. That's why. And this judgment in this case will have a far-reaching impact. That's why we are granting it. On 6/4/2023, Mr. Kiran Javli had appeared on behalf of respondents and had sought for an adjournment. And below. Today, when the matter is called, Mr.
Yes, Segre.
Mr. V.S. Hegde, learned SPP2 has appeared and prays for adjournment. In the interest of justice, by way of indulgence, hearing is deferred. It is made clear that no further adjournment on any ground shall be granted. You have to be here. Don't say that pass over and all that. That's why this goes. Repeatedly, you have sought adjournment. There is a limit. They are behind the bars. At least we need to pass an order, whatever, one way or the other. So if you reject it, he will take recourse to the higher. But we can't, like we are approaching vacation, we can't. You are trying to think that it should go beyond vacation. That we will not come. He has already argued the case. We have told you, and we have told you, and this is not our job. Still, we have told you what he has argued. What your colleagues are doing then, if you are not here then. This tomorrow for further. Please answer this. Please answer query. That's all.
Yes, but you will come, sir. Speak. That's part of the procedure. All right. Okay. Stay there. They would have given you picture.
The way you are smiling, that gives us an indication after vacation. Huh? Huh? No. Whatever. Submission is adjournment. Huh? We should wait when they will find time and when they come to you.
This appeal is only for the enhancement of permanent element.
Enhancement of permanent element. She let her argue.
Whether you filed affidavit, madam? Affidavit of assets and liabilities. Not filed, huh? Court has awarded.
So
Family court is
he
awarded.
he could predict the results of this case.
10 lakh.
Learned counsel for parties jointly pray for adjournment. List after. This, see, last time also are not present. What, madam, you don't have any accountability to your clients 7 years. What do you tell? That case was listed, how it is adjourned. That court was dismissing the cross objection with great difficulty. I sought an adjournment. That's what you tell, right? And that too, you do it with a smile, not a remorse. We are ready to hear. Last date also we adjourned. Perhaps it appears to us that we are more eager to get maintenance than you. Its amount will be paid to us, something like that. Let it be adjourned. When it comes for parties, we pay for it. Next stage, we will not adjourn, madam. Second time, it is first time we have granted adjournment. Second time it's being granted. Third time, if it's listed before this court, no adjournment shall be granted. We will decide it even if you don't come. Current counsel for the appellant once again prays for adjournment. Across objector once again prays for adjournment to enable her to prepare the case and argue the same. List after it will be also you file it. It is open for you. It is open. We have. You are ready to argue, then please argue. Ready to argue? He's ready. Yes.
The cross objector and the respondent was performed on 16/1/2010. The plan was objected on 19/1/2010.
Now you are seeking 25 lakh crore. There is, you are. Not nothing to do with this grounds and all is not important. You, what is the basis? What you have pleaded about the his income? What you have pleaded? What is the evidence?
Basis for 10 to 25 lakhs.
Then you are saying there is no basis. Then how for 25? What is it? Where is that? All this evidence we wanted. Take us. No, for the family. No, madam, you have filed the challenging the order judgment of the family court dated 10/8/2015, saying that amount of 10 lakh is not properly considered. They ought to have awarded 25 lakh rupees. No, then what is the basis for that? 25. No, that cannot be oral. Should be by the documents.
It doesn't happen, madam, that you seek a modification of a judgment and decree and say that I will adduce evidence later. So the question, this all material, whatever you are relying upon, should have been before the family court. Then only you have challenged the judgment dated 10th of August 2015 on the ground that it awards you 10 lakhs only, and the family court ought to have awarded 25 lakhs. So what is that is what my lord has asked. What is the evidence to show that it should be 10 lakh is all the sum which is inadequate and 25 lakhs should have been granted? Show the evidence. It is before the family court, not now. What?
Then that is the reason, madam. There is a section 25 is there. You can file a petition before the family court and seek modification, alteration, whatever. If change circumstance and evidence is available, without any material, how will enhance automatically first? When there cannot be a kind of rowing inquiry in this appeal. No, you from the trial court record, you point out what is the material you have placed to come to the conclusion that no, 10 lakh is insufficient. 25 they would have awarded. What's the material to that effect? Because we are examining here the judgment of the trial court, not his income, maybe something more. We are not concerned with that. That you have a remedies under the law.
The main estate, now the main estate is getting. Day by day, the.
That, madam, no, no, madam, we are not here to advise, but there is a mechanism under the act itself. You can avail that if you want. You can produce all those documents there, file a petition under section 25 and produce all the evidence, trial court can consider, modify that and enhance. That is permissible, but based, we cannot go more than this. We can't ask you to bring that and then you ask him to cross-examine here. It is not permissible. What is available on this, we have to examine. We are requesting you to show from this what you have produced before the family court. Prayer 2 you have made a lump sum maintenance of 25. Then how we have to view what you are saying may be right, but how we have to accept it?
What do you do, Mr.? What is the evidence with regard to you? And nothing means you don't do anything. Huh? What is it? Huh? Huh? No, but you have a daughter. Mr. You have a daughter. What is the age? 12 years. You have argued matter no evidence. Now we are trying to find out.
10 lakh rupees.
So,
We paid 10 lakh rupees.
Yeah.
Madam, what is that? Have you filed execution? Execute.
Yeah, parents are.
yeah. You are behind the bar. No, no.
What?
So he has tasted blood, right? So he knows nothing happens. Once more, he will go and enjoy and come back. Huh? Like that, you. We are trying to. You have a daughter, right? Huh? What is these 12 years of age? So then, mother is taking care of the daughter, right? What? Yes, you say, madam.
He is having a very good business, my lord. He's doing the.
Madam, except para 38. That way.
Please point out what is the evidence we are repeatedly telling you. You are the orally saying doesn't, it will not help you. So you keep what, let her argue. When we try to interact with you, she interrupts, let her argue. We thought that she, having told that there is no evidence, we thought that she doesn't want to say anything. That's why we were trying.
18 of the.
Para. Madam, madam.
Wait, let Rajneesh versus me. Are their presence, learned counsel in view of law laid down by all. Right out, mark their presence. Dispute in this cross objection only pertains to quantum of permanent element. In view of law laid down by Honorable Supreme Court in what case? Rajneesh versus Neha. You know, all parties are directed to file an affidavit pertaining to assets and liabilities within 4 weeks list after ensuing.
Sorry. Draw the inference. You have to file. Whatever the removables.
Hearing for the opponent. We don't have any instructions from the client. Only the matter.
Learned counsel for the appellant submits that he has no instructions to argue the appeal. The aforesaid submission is placed on record. The appeal is dismissed for want of process. We don't have any instructions. We have recorded.
It's unwell. Last time we spoke to him on last date of occasion. He was unwell. The matter may be taken there.
Why?
You don't have any.
You have not withdrawn Wakala Kama. You have not filed a memo of retirement. Then you have to argue. He is unwell. He's not required to come here and argue. He is unwell. He may be unwell. That's why he has engaged you, right? Then how can you seek an adjournment? We have known so far that counsel is out of position. He is unwell. Now you are seeking an adjournment that Client is unwell.
He is arguing or you are arguing?
Who is arguing? Appellant will argue or you will argue. Then how you are seeking adjournment on the ground that appellant is not well?
He needs some instruction from me.
No, nothing. You have said no instructions. That is dismissed.
No, no. So, I'll get instruction from the.
Don't say recklessly, Mr. Anything. This is High Court. Please appreciate. Don't say we are not moving around in Cubbon Park where you can say anything. You said that you don't have instructions. What does this mean? That you have no instructions to argue. That's what you told. Now you are saying pass over. What I mean, do you know? And you are seeking an adjournment on the ground that appellant is not well. Can we grant an adjournment? Appellant is not required to argue the appeal. Otherwise, he would have appeared in person. Why will he engage you?
Hey, 5 years, what we have to do?
Please help us. He's not understanding what we are trying.
Last date also, please read this. You know the reading, no? You please read that.
Please read this,
2016
at
appeal,
least
what we have to do? Please read that.
Mr. Amicus is saying that he has no instructions. They have dismissed the appeal. So he says appellant is not well. We are asking him appellant if he has to argue. He would not have engaged.
So please read that.
Please
Loudly you
read
read.
the order sheet.
Loudly you read that.
For the appellant, also taking place for an adjournment on the ground that appeal counsel.
On what date? On what date? Date. Even today we are on what date? Again, you are saying that appellant is not there. On that day, counsel was not there. Today, you are saying that appellant is not there.
No, it can't be. Please argue.
You want to argue, argue.
Please argue.
Otherwise,
We will keep the record. No, no pass.
2016.
This is
appeal, no?
MFA. There is nothing to argue. Please go ahead, read the judgment. You will understand what is it. No, we doesn't go by your convenience, Mr. Please understand. We will say that when the called upon to argue, he says that I will do it in the afternoon. That means whenever you get time, afternoon 4:30, you will come, and then we should hear. No. If you want to argue, please argue. You don't have file, we will give you the file. Amicus will help you in arguing. Mr. Government Advocate, though it is not his job, but we are requesting him, so he will help you in arguing the appeal. Tell him what to argue. Tell him. How many times, Mr. Adjournment means what? It is not a joke, right? How many times we will adjourn? Hey, yes, Mr. Hegde, why are you standing there? Acha, next matter. Oh.
You have copy of the judgment or not?
Huh?
Please read it. Para 2. Who has filed this appeal? Who has filed this appeal? Who has filed this appeal? Ah.
In 13th, when began.
Petition has been
And
dismissed.
dismiss.
We are asking him to read the judgment. Is it that difficult?
Read.
Huh?
Read.
You have
Para
done
two.
law, right? You have done LLBD, obtained LLBD. You can't read the judgment. Speak into mic.
Then they started their life at the smart home in Bangalore. It is like if the respondent has been after it began to at the time the mother of the petition had given him a child and the petition had given to the respondent. The mother wanted to attend to have no they came and added well, And them TV that there was no failed to establish the ground of priority against the respondent. The petition is also filed under section 13 clause 1 IB of Hindu Marriage Act of 13 of the petition arose on 16/12/2002. After this clause of action, the petition came to be filed in the year 2004. According to section 13 of Hindu Marriage Act, the petition can be filed for dissolution of the marriage on the ground of divorce when there is a continuous period of resolution of not less than 2 years. Petition in above case is only 1 year according to the petition. Therefore, this provision does not attract in this petition. The petition is entitled for any relief given under the ground of desertion. In view of this fact, my answer to point number 1 and 2 are the negative. Point number 3, in view of my finding on the above points, I put are the following order. The petition filed under section 13 clause 1 I and IB of Hindu Marriage Act 1955 is hereby dismissed without cause.
Whoever pleaded is admitted in cross-examination saying that everything is wrong. You have met her, condone the acts, assuming that she has done some acts also. You have gone to her house in Nagar and stayed, paid maintenance, paid school fees, and you have said that we have a good relation. If she comes also, I have no difficulty or divorce. It amount to condoning the act, assuming that something has happened. It's an argument, sir.
Counsels cannot argue. Tell him whatever you want to.
The date of filing of this petition till date, they are not together.
Here, what she wants to say.
Yes, madam. You want to say anything you had? The duration is important or what? To prove the reservation.
Nobody else will come to argue, right? After you, nobody else.
Have you read the cross-examination of PW1? Is it the cross-examination dated? White and 2007. Please read that. Please read that. Records, NCR records. Trial court records are there. Is your evidence, no?
One in which he was son of so. After cross-examination on the previous day, I must have met respondent and my daughter in their house. My wife is in a rented house at Nagar. There, I will be often meeting my wife and daughter. I cannot give the exact address, but I give the location. My wife herself gave the address. We used to talk in Nagar house. My father and mother knows about it. It is correct to suggest that my father comes every time to the court. It is also correct to suggest even today he is very much present in the court hall. There was no quarrel between my wife and myself when we met in Nagar house. There was no incident of assault or quarrel between myself and my wife at another house. I was not requested my wife to come to stay in our house. There was no problem or difficulty in calling her to my house. It is correct to suggest that myself and my wife are in cordial terms. It is correct to suggest that I have paid last payment on 3.
Give me that. It's sufficient. You read, no? What he says. So earlier, assuming that some acts are there, you have condoned those acts, visited him. The reality. And earlier acts are again, you have admitted in the evidence that there is no complaint, nothing, only assault, sharp weapon you wanted to, his brother wanted to assault, etc. Nothing, no complaint. Instead of CS filed complaint against you.
Now,
Which provision of law says that 20 years residing separately degree should be granted?
We have read it. This is sufficient. No?
You also read it. Good exercise to vocal cords, right? Huh? Oh. Few months. You
good
see,
job.
should argue MFA. Good job done. There's nothing,
Opponent is not there. No. Good thing, whatever you say.
there's nobody to come forward or
Anything,
counter your
anything.
submission.
Anything wanted to add? Here also, up to December, when you have left her house. For that also, you have not stated anything. Not stated anything. He was admitted that I have not given the complaint for that. That's all. Daughter is there, no? 12 years. 12 years old daughter.
Are there appearances? So and so, write her name and so arguments. None for the respondent. Argument hurts. Arguments heard. Case is reserved for delivery of judgment. What happened? Right. You have filed. It's very agreeable here. It's here. Weeks time. 4 weeks time by way of file an affidavit pertaining to assets and liabilities. List after ensuing summary.
The traffic inspector. They challenge 3 punishment order before the labor. The labor court. Several documents has been marked. Both 8 heard the matter and without appreciating the evidence as well as documentary evidence or evidence and reject the this award is annexure D page 31. Page first. Award in page 31 in award page 42. Read. Read the reason. Nothing between page 42.
What happened? You were traffic inspector.
I am the traffic inspector. There are three charges.
What charges?
There are
Three
three.
inquiries or three charges, madam?
No, different punishment order is different.
So what these, no, three punishment orders have been imposed in pursuance of three departmental inquiries. What is the first inquiry? What was the charge against him? No, this 17/9/2005, 28/10/2005, and 30th April 2004. What is 30th April? Reduced. Just a minute. What was the charge against him? Unauthorized absence from so this resulted in this imposition of reduction of pay by one incremental stage, 2 years. Just was 128 in 2005. What is the charge? Schedule. Schedule of what?
Buses. Running the buses.
What is third? So this all 28/10/2005.
Okay. Without time.
So what is 27/9/2006? Then what has been done by the labor court? What has been done by the labor court? 7, all three. What is the ground of challenge?
No, not significant. On that, punishment order, first punishment order, 34 people. I will try now. The different charges.
She has told no. Incorrect. What she has told is incorrect.
By reading, not significant. See?
No. We are asking you are challenging the award passed by the labor court.
Yes.
Single judge is appended.
Yes.
What grounds you are challenging the award?
What challenging is,
What ground?
first ground, I have given leave application along with medical certificate. When the duty of the depot manager to sanction my leave application, I have produced before those documents before the inquiry officer and marked the evidence produced before the inquiry officer MW1. He admitted he has given medical certificate, leave reply to the charge sheet, article of charge, and also medical certificate. Therefore, my question is, but once the
Where is the evidence? What evidence you are referring?
nothing. The evidence
It on record.
that has been recorded in the part. Kindly see the award. Page 31. There, page 52. 52. List of documents marked for list first party. Letter to law officer. Reply to article of charge dated 13/8/2002. Copy of acknowledgement marked in inquiry. Copy of acknowledgement marked in inquiry. Reply to the charge sheet 29/8/2005. These are the documents marked. The labor could not appreciating those documents.
Where are these documents?
Documents in the file.
Documents in your file. Let it remain there with you. We will decide the case in the absence of documents. Let it be with you.
You are reading the list. We are searching where are the documents. At the end of the award, you're reading the list, exhibit,
What
W1 letter
You
of the
apply to articles of charges.
Those documents are not put in the.
There are those.
Trial court did not appreciating of those documents. All for records. All for records.
You have not filed it. Can be done.
I did it. Before the runner single judge, I thoroughly repeatedly said, but they did not take this. But therefore, I obtained certified copy. What are all documents? What are all documents?
How can we accept? We can't accept like during the final hearing some documents you are passing on like.
It's true. But not to can see the where copy obtained in the labor court. I got it. Those documents are filed. I have given applied a new letter, new application, along with medical check. And before inquiry officer, the labor court, inquiry officer admitted they are given all documents. There is evidence forthcoming in their inquiry officer evidence. D1 and D2 is marked, and those documents are marked. It is not.
Sir, unless you file, we will not be able to look into that.
Later will be a time. Count in the don't itself is additional documents.
Yes, but after. Then it comes to the appellate. After arguing the matter, so next, we learning counsel for the appellate. Again, this thing. Last date also you sought time to prepare the case.
Yes.
Today also after arguing you want the.
She did not appear last time. Therefore, I wait for a long time. I sit here and she did not appear. Therefore, I.
Therefore you sought time.
Don't
So,
get-
so nice, so nice. Learned, very considerate, right? Learned counsel for the
You
appellate.
open the essay.
Praise for adjournment, enable. File. Some documents which were placed on record with the labor code. Just after issuing some.
LCR.
You file, Mr. Ah. So, Mr. No contested case this side of the vacation. Has to be big, you are appearing so.
No, I think last time we were inquiring whether they have completed the course and
In
That's-
this, the manner in which this matter comes up is the petitioners before the learned single judge were parents of students who had filed an application for de-affiliation of the school.
that last time he wanted to,
anything
your colleague wanted.
No, nothing survives in the writ petition for this reason.
All right, that
No, no, 1 minute. Nothing survives in the writ petition for the reason that the students have taken transfer certificates and left the institution. But the learned single judge's order remains. And if your lordship looks at the order passed by the learned chief justice as he then was, dated 24/7/2019, when the appeal was admitted. Please have a look at that order, my lord. April.
So we will hear it after vacation.
Because it says,
Mark
Can say
it.
that.
Lord,
We can-
because the main issue is, whether a writ petition under article, whether a writ petition under article 226. The main matter is whether a writ petition under article 2.
No,
We'll
I-
hear it.
no, I could not read it, sir.
It is what the learned chief justice said.
You are appearing, that means it is required to be heard. We said no heavy matter this side of the vacation. In the beginning, we said.
I'm okay.
Learned senior counsel, so and so. But where is that counsel who appeared, Mr. VC Raju, he disappeared. He has sent you.
He has engaged me and gone. I have my colleague.
Let the appeal be listed after ensuing some application.
He will.
Right.
Every information from here. Everything something you put up banking drop also. This all.
Short accommodation, how short?
Tomorrow.
Why accommodation?
My senior is supposed to,
Where is your senior?
he's appearing.
It's not a court. This is a division bench, right? Which court is appearing? So which precedence should be given? Where? 23 is not. No, 23 is not division bench. So which, where the lawyer should give precedence? Which case? Tell us, we want to know, division bench. When he is appearing and he has said here, that means there is nothing in the case. Huh? The case. You have a case. What is the case? Huh? What is the case?
First respondent,
So what happened?
there was some allegation.
Ah.
Misappropriation.
Ah.
Inquiry was held. The inquiry authority. The report was submitted and disciplinary authority of respondent number 1 has imposed compulsory retirement or penalty of compulsory retirement.
Yes.
In which but it was dismissed.
Wait. Good. Note that. We are happy that why means why, what is the reason assigned by the learned single judge for dismissing your petition? Like most of them, you are not this thing. We are happy that you are not even referring to petition. Good. So that's how, why it has been dismissed. What ground?
There is a delay in preparing appeal before the tribunal.
That's why petition has been dismissed. Why learned single judges dismissed, Mr.
No, we have prepared appeal before appellate authority under Spices Trading Corporation Limited. Some delay matter. On this ground, writ petition is dismissed.
Delay in filing the appeal. How much delay? When was the order passed of compulsory retirement? And when did you file an appeal?
The order passed on 7/5/2014.
Filed an appeal when?
27/2015. 7.
So 1 year and 2 months. So that's why writ petition is dismissed. So what is the reason for delay of filing it? See, last case of here. Show it. Last, read the order aloud. Read loudly. See. Then what did we say? What is the ground? How many times adjournment?
Last chance.
Last time? Why? What is the ground? Last date of hearing, he was out of station. Right? Not available. Give the file. Today you will have to at least tell the reason for seeking adjournment, right? What ground? This appeal is pending. This petitioner has forgotten about the case. It doesn't contact me what is happening to my case. Huh?
Para 5 something is different. Please read para 5.
Please read para 5.
Para 5 of the order of the rules. Page 24. Yeah, challenge it. You are not challenging this.
Read para 5 of the order.
Same design.
Next para. Nothing. If you, no, there's no question of please.
Chance
You have read it.
by filing another.
You have read it, right? You have not challenged the order. Nothing. No. What he will tell you. No, you tell us, can the doctor say that I will seek instructions from the patient? Huh? Can he say, you are an expert, right? What will the petitioner tell you? It has to be, you have read paragraph 5 and 6, and if you understand English, you have understood what it means. Then there is nothing absolutely. We would have adjourned it. There is nothing absolutely. You did not in earlier round of litigation. You did not challenge the order of termination. You received the terminal benefits. How can you maintain this petition subsequently? And that too belatedly? Nothing. Yes. No. So what is who is your senior? Sri Satish K. Learned Counsel for the appellate. Sir. No, we are not asking you. There is no question of convincing. We are marking your senior's presence.
You will understand, don't worry. You will understand.
Sri Satish K. Learned Counsel for the appellant. Third, this intra-court appeal has been filed against an order dated 24th October 2019, passed by learned secretary, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant was employed as General Manager Finance with Spices Trading Corporation Limited. Spices Trading Corporation Limited, SPICES. Spices Trading Corporation Limited. Full stop. Domestic inquiry was held against the appellant. So, a domestic inquiry was held against the appellant, which was entrusted to Central Vigilance Commission. Full stop. Preliminary inquiry commenced on 23rd May 2011. The appellant attended the preliminary inquiry. However, he requested for providing some documents. Thereupon, the documents were supplied to the appellant. Paragraph. On the basis of the inquiry report, the disciplinary authority passed an order dated 7th of May 2014, by which penalty of compulsory retirement was imposed on the appellant. The appellant filed. The appellant challenged the same by filing an appeal after a period of 1 year and 2 months. Stop. By an order dated 3rd of November 2016, the appellate authority upheld the order of penalty. Full stop. Thereafter, this paragraph, the appellant thereafter filed a writ petition. Which
Yes. Clear writ petition. 2050-2018. Objection appeal.
The appellant thereafter.
Objection filed by
the paragraph. The appellant thereupon filed the petition, namely WP number 2050/2018, in which the appellant sought the benefit of leave encashment. It is pertinent to note that in the aforesaid writ petition, the appellant did not challenge the order of dismissal from service. Full stop. The said writ petition was allowed by this court, and the respondents were directed to pay terminal benefits to the respondent, and the respondents were directed to pay terminal benefits to the appellant. Right? Paragraph. Thereafter, when this petition was filed, thereafter the petitioner, the appellant, thereupon the appellant filed this writ petition in 16/1/2018, that is after a period of 2 years from the date of passing of the order by the appellate authority. order by the appellate authority. Full stop. The learned single judge by an order dated 24/10/2019 has dismissed the writ petition. Full stop. In the aforesaid factual background, this appeal arises for consideration. Paragraph. Learned counsel for the appellant. Learned counsel for the appellant submits that the impugned order dated 24/10/2019 passed by learned single judge suffers from the vice of non-application of mind. It is further submitted that learned single judge ought to have appreciated that the impugned order of rejection of appeal dated 3/11/2006 passed by the appellate authority is without any application of mind. His senior's name and his name. Right? Full stop. Paragraph. We have considered the submission made by learned counsel for the appellant and have perused the record. Full stop. The order passed by the disciplinary authority was challenged in an appeal which was filed after a period of 1 year and 2 months. Full stop. The aforesaid appeal was dismissed by the appellate authority by an order dated 3/11/2016. Passed by the disciplinary authority, and appellate authority was challenged by the appellant in a writ petition which was filed after 2 years. Full stop. It is pertinent to note that previously also the petitioner had filed a writ petition, namely WP number, you got number, right? WP number so and so, in which he had only sought for payment of terminal benefits. In the said writ petition, the petitioner did not, the appellant did not pray for either quashment of order passed by the disciplinary authority or by an appellate authority. Full stop. Therefore, the subsequent writ petition filed by the appellant, therefore another writ petition filed by the appellant, was barred on the principles contained in order to Rule 2 of the Code of Civil Procedure. The full stop. In addition, the appellant did not disclose any cogent reasons to demonstrate as to why the appeal as well as the writ petition was filed relatedly. Full stop. Paragraph. For the aforementioned reasons, we do not find any ground to interfere with the view, with the conclusion arrived at by the learned single judge, line 0 in the result. Mark your senior's presence, don't worry, not you. We have marked his presence. You tell him that I argued well. Right? Tell him that you argued well. The court has told you.
He's scared.
Huh? Correct?
Service lawyer is colleague. He is colleague, a service lawyer. He may be knowing about the case. At least regular service lawyer.
My brother tells me that he is a regular service lawyer. He
Don't
understands
merit
what
of
is
the
what.
case. Don't worry.
Don't
Not
worry.
relenting.
Don't worry about
Inform Satish.
Huh?
He
What
regularly.
is
He
it?
is regular.
Huh? Yes. More time for to do what? Uh, Learned counsel for the appellant wanted to prepare the case. That's why we have adjourned. Now you want to prepare. If we don't grant you adjournment, it will be violative of Article 14, right? How can we grant adjournment to counsel for appellant and not to you? Correct? So if we have granted him 2 weeks time, we should grant you 4 weeks time. Correct? Huh? No, explore the possible. Means like cases pending since 2016. And when the case is called for hearing, then only you all of a sudden realize that we have to explore the possibility. What? When 29/3/2023, almost, I mean, like 15 days ago, what did you explore? Nothing. Settling. The appellant is not here. No, sir. No, that's correct. But for settling the matter, consent of appellant is also necessary that you will settle on your own next party. Nobody is there for the appellant to say that we want to settle the matter, therefore it be adjourned. He is not appearing. What ground? 20 years, you want it to remain pending for another 10 years, right? No. Huh? Yeah. Done for the appellant, Mr. So and so, learned counsel for respondent, praise for adjournment to enable him to prepare the case and argue the same list after 4 weeks. You cannot settle the matter unilaterally. Do you understand at least this? So how, I mean, appellant is not there. How you are saying that I will settle? You can't settle. Yes. So then, if you can't settle unilaterally, then what? That means you have not read it. It's their petition under section 13 on the ground of desertion, right? Has been rejected. He has to argue you are seeking adjournment. So either you have told him, don't come, I will see to it that it is not taken up. Huh? You have assured him that don't come, I will seek an adjournment. At the most, the court will dismiss it. For default, you later on file an application for restoration. I will not oppose it. It will be restored. Then, honestly, no, then what is it not to argue, Mr.? Petition has been dismissed. This appeal will be dismissed. You should have jumped at this opportunity. Nobody is appearing to oppose you. Correct?
I think only nothing is there in.
Huh?
What
What
is
is
the
it?
judgment?
Can you read the judgment to us? Huh? See, I mean, see, he is not there. He will file an application for recall. They already none for the appellant, learned counsel, Mr. So and so, learned counsel for respondent, praise for adjournment to enable him to prepare the case and argue the same. List after ensuing summer vacation. Right is there, she's seeking adjournment in her presence. That's what I'll say. Oh, that's fine. The ground of cruelty.
It is not mentioned in the. only 31. All the grounds, sir.
The court has to understand, right? What ground is made of. Huh? So that you can argue. No, supposing if the court dismisses the petition on the ground of desertion, but so that you can argue in appeal. No, that was not the ground on which I had sought. I had sought on the ground of cruelty. The judge has not understood. Good idea. Huh? Understood. Correctly understood. If you don't mention provision, what the judge is supposed to. Correct. See, without seeing, we correctly said that this is this thing. What a fabulous argument. That file it under the ground. If the court decides, then in an appeal, argue that I had never filed it on desertion. It was cruelty. The judge has not understood.
What was there? Trial court has considered it.
Then you, if according to you it is on the ground of cruelty, then you should have filed a review saying that I never filed. What can be done? This. Left the petition. Is it? Adultery also you are free. Adultery and desertion.
Wherein the person, there was a criminal case against him.
You implead him, that person.
You are not.
No,
That document has also not been produced. I have produced the document now. The additional.
like read paragraph 16, you will find the answer of desertion.
That opponent says, even now she is deciding. The admission given by the petitioner also shows that he is living. But that is not correct because she was living in a one portion because both are
Living separately doesn't mean that intention. Like 2-bedroom apartment.
no,
So you say that wife has deserted me, shifted to the other room.
Ashreya house, my lord. There is two portions. One is she is residing and another portion is he is residing. Because there was a quarrel between them wherein after that incident where she was having a relationship with Aruna. And then
Some room means he has to be a party. If he is not a party, then that's the end of the matter. You know the law, right? So ground of adultery does not survive. Now you have to prove the desertion.
reality may also be a matter that
She is now ready to live one, not animus desiderendi, not to.
the complaint, the statement she stated.
Which paragraph of the petition? Cruelty, this desertion. Continuously for a period of 2 years.
Last 2 years. Which is not have patient.
Which years deserted? In the last 2 years. Years. Give the date. Right? Date is not specifically not specified. Mister, did you bring out to the notice of the family court that I have filed a petition on the ground of cruelty also? Did you argue? Just like saying 30. Did you argue that I have filed a petition on the ground of cruelty also? Then leaving everything to the court, right?
is an allegation and there is an application.
No, the court has treated your petition. And no, the court has treated your petition to be on the ground of desertion and adultery. So you have not this thing impleted that person. So question of adultery cannot be gone into. The only other thing is desertion. You are arguing a third ground. We will relegate it. If you want to withdraw this, withdraw and file a review saying that I had filed. The ground of cruelty also family court has refused to entertain. Issues were framed. What were you doing? You cannot just like reading one paragraph. You can issues were framed in your presence, right? Then whether any issue was framed by the family court on the ground of cruelty, and if it was not framed, did you point out to the court? Like if final hearing in appeal, you can argue anything that it's no question of remand. Why? Why should we remand? We are asking you, what did you do? Issues were framed in your presence. If issue pertaining to cruelty was not framed, what did you do? Just because there is a decree.
Evidence has also not been wherein criminal case was registered, wherein her statement was recorded that he was kidnapped and he was assaulted by that person.
When were you kidnapped?
Kidnapped by
When? 2011, right? So this petition was filed on 24/10/2011. So this fact was within your knowledge that you were kidnapped. The question is, Mr. Additional evidence can be permitted, provided. I mean, if you are pleading about the facts or documents which have come into existence subsequently, what prevented you from this thing? We will have to ask the question. You have to, what are the conditions of production of additional evidence?
Even height of my
Due diligence. So what is 2011 you were kidnapped? You did not know that you were kidnapped.
stated in his evidence, but document.
So you have to thank the lawyer who has conducted the proceeding.
That to a statement before the police, whether it is admissible.
Statement.
We have given some, say they, police how. It's not evidence recorded, full state.
As a witness for the police. It was not about the custody of the recorded custody.
No, we will.
Okay, it is a
2011. What is the reason for not production? This conditions are not fulfilled. 2011 document well within your knowledge. Why you did not produce it? You cannot do at the belated stage after that too. In 23 you have filed the application. Go ahead, whatever you have to argue, please.
It's just that I am having any. For that, I am not. That has not been substantiated. Even making such allegation, because the allegation and counter allegation made by the party is the marriage. Parties cannot use in the lead normal life. Under their such circumstances, even the remedy part it is because of the allegations against each other, because she is not waiting for the petition. The appellant, the respondent is also not having any appellant. Marriage life. Sorry.
Dated 28/6/2013. ಅದೇ ಸಾರಿ ವಾಸ ಮಾಡಿ ಮನೆ ಪಕ್ಕದಲ್ಲಿ ನಾನು ಇನ್ನೊಂದು ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡಿ
26/10/2013.
8/6/13. ರಾಸ
Six to 2000.
28/6. ಮನೆ ಪಕ್ಕದಲ್ಲಿ ನಾನು ಇನ್ನೊಂದು ಮನೆ ನನ್ನ ತಂದೆ ತಾಯಿ ಮನೆ ನನ್ನ ತಮ್ಮ ಪ್ರತ್ಯೇಕವಾದ ಮನೆ ನಾನು ಚಿಕ್ಕಮಗಳೂರು education. I am having
Objections, see stated. State no objections whether they are stated. What you have read, the same allegation is there. Allegation. Lawyers unwanted questions. Do something. That is not. She is not pleaded, no. She has not pleaded that you are adulterous life. She has not stated anything in the objection. It is not pleaded only. There is no averment of cruelty in the petition.
No, and no issues have been framed by the family.
No
court.
issues, no even.
What did you do if the issues were not framed on cruelty?
pleaded
Why you
also.
did not file
No, absolutely
an
no
application under order 14.5 saying that please frame. Going in final hearing after 7 years that I filed a petition. Whether your action of this thing not mentioning the provision is justified.
even one
Misleading
instance of
the court.
cruelty also. I don't know.
Or something, even the prayer also, they are not specifically stated, it is null
Not
and
even-
void they have stated.
No, it's all right, but even in the pleading, not even in one instance.
Family court should have said that it is this relief is claimed under section 12, but no grounds have been pleaded. Therefore, dismissed paragraphs. Then you would have been fine. Everything is on the court, right? What you tell us, no. Smiling won't have. Please tell us. The family court on the basis of pleadings of the parties framed issues. The issue was not framed with regard to cruelty. What did you do? Did you tell the family court that I have filed a petition on cruelty also? Please frame an issue. Nothing. And you are after 7 years, this actually is pending since 2016. You are arguing that I had filed a petition. Fine. This can't be done.
It is not mentioned. The prayer looks like.
We will consider your submission that it is on the ground of cruelty also. Anything else? Oh, nothing. You also know, right? What will be the result of the appeal? You also know. Half-heartedly you are. Right? Reserved non-corresponding reserved for delivery of check. So reject the prayer. These facts were revealed within your knowledge and no explanation for producing it belatedly in the year 20. 2011 you moved that you would have done. Yes.
By my party. What has happened is that my party is unable to contact his lawyer because order is admitted to the hospital. That's what we said. Therefore, I could not bring it to the court. What exactly?
Mr. Shivramu SC Learned Counsel for the applicant non-correspondent list after ensuing submission.
Sir, not appeared in serial number 41. Seal case. Yes, sir. Old man.
But how this?
Which is the subject? Same council has not appeared in 41.
See, I mean, here also this order was passed list after ensuing summer vacation. 22. It's coming up today. What is your remedy? To seek a modification of the order passed by the tribunal instead of fighting it out here. No, the reasoning is, we hope that you must have read the file. The learned single judge held that the order of the tribunal is not executable because there is no quantifiable determination of the liability to pay the amount. So if it only says back wages, they say 2 lakhs, you say 4 lakhs. We don't decide in the writ petition. What is the proper this thing? You could have sought modification of the order passed by the tribunal and then execute it. You are wasting time here.
Based on part of the tribunal, the execution amount has been quantified. Challenging that order of execution, the respondent institution has filed an appeal and the upper single judge the petition. The effect that the order itself is inexecutable. In fact, in the execution petition which was filed with the appellate hearing, the amount the back wages to be payable by the respondent institution has been quantified and the sum of which is 15 lakhs is ordered to be paid. RFM is pending consideration. The institution has filed RFM.
So subject to decision of the RFA, you execute if you succeed. What is there to?
Raise that ground also. Executable or not? You have raised, no? Sir, you have raised that ground, it is not executable. RFA. Do whatever.
Which order executable court, executing court has held 15 lakhs?
Sir.
Date of order.
RFA, what is the number of
Mr.
execution?
Yes, you say that
13.
1297. Which order has been assailed in that RFA?
Date of the order.
Date of the order. Simple. He also don't know. He doesn't know.
RFA date number. Get the order.
So which order?
Those documents were not on record. And
There is nothing. We have understood what is there. Nothing on. No need to be on record.
Which order is challenging this RFA?
Mystery. You are trying to tell us that in an execution proceeding, the executing court by an order has quantified the amount which is payable to you on account of back wages to be 15 lakhs. Against that order, an appeal has been filed by the management. So your right to this thing, get that amount will depend on the outcome of RFA or not. That's what we are saying, that subject to result of the RFA, you will be at liberty to execute the order passed by the executing court, which is in your favor.
the order of tribunal was not. The order passed.
Sir, all right. What is the effect of this order? Now this effect, single judge has held that it is not executable, but it's already our determination is done and they have challenged. We'll keep open this contention whether it is executable or not. Let the RFA court decide. We will not say anything in this. We'll just record that after this execution is filed, in execution determination is done. Against that, management has filed RFA, which is pending. The outcome of the RFA binds the parties and they can, whatever the, if are entitled, otherwise no, RFA court will say whether it is executable.
One other submission.
Whether it is challenged, the AT order is not concerned with that.
In the repetition of the challenge before the London single judge was to the order passed by the government, where they had refused to give me continuity of service for the period which I was restrained from working. That was the order under challenge before the London single judge.
He has not considered that. The file review
Has not referred to the order passed by the respondent government. However, before the London single judge, the order of the tribunal was not under challenge, but the London single judge has come to the conclusion that has assigned findings to the veracity of the order of the tribunal. In fact, the order of the tribunal was already challenged by the management ERP, which came to be dismissed as per Annexure B.
What is the submission? Paragraph 2, your submission is recorded. Read. Sir, you will argue anything before single judge and argue something else before division bench. Why should you not file review? If that was so, did you argue anything about validity of the order dated 6/4/2010? Nothing. See para 3(2). No, please read it. No, please read. Very conveniently skipping is not sufficient. Read para 2.
Tribunal has ordered and directed to pay entire back wages to the petitioner and denial of the relief by the respondent is improper.
Then para 3.
It is disputed by the learned counsel for the respondent. He submits that an amount of rupees 2 lakhs has since been admitted. It has already been paid to the petitioner. The rest of the amount is disputed.
Then
On hearing that,
this is what you argued before single judge. When he decides, in case you feel that there is something else, file review. This is not the this thing. Appeal will not permit you to raise new contention. In case you want to say that we had challenged the order dated 6/4/2010, file review. Yes, this intra-court appeal has been filed against order dated 23rd August 2018 by the single judge in number 40634 part 2010, by which a writ petition preferred by the appellant has been dismissed. Paragraph. Learned counsel for the appellant submits that challenge in the writ petition was made to the order dated 6/4/2010, passed by Secretary of Rural Education Society, which is passed by passed by Deputy Director of Public Instructions, the validity of which has not been challenged. Full stop. Paragraph from paragraph 2 of the order passed by the learned single judge, we find that the issue with regard to validity of the order dated 6/4/2010 was never urged before the learned single judge. However, in the peculiar facts of the case, we grant the liberty to the appellant to file a petition seeking review of the order dated 23rd August 2018 if so advised. With the aforesaid liberty, the writ appeal is disposed of. Adjournment. Why? Vacation is yet to commence. He has already started enjoying vacation. No. But you also, right? You also want adjournment. She's praying. So she's praying for adjournment, right? What to Lead counsel for the appellant prays for adjournment. Now that arguing counsel is no,
Where is
out
he?
of station. He can appear through video conferencing, right? Out of station. Just after ensuing summer vacation. See, no, are we here? Are we not hearing this appeal finally? Yes, quantum. Wait, wait.
She fights stating that he is not looking after me and
So what is this appeal matter? What has happened? You are a wife, husband. So what petition has been dismissed? So what on the ground of cruelty and desertion? All right. So what is this IA about calling the order dated 3/6/20? What is 3/6/20? Dismissing the appeal. Drawing 1 lakh.
kindly see.
This is a case where you have settled abroad along with wife, a second wife.
No, you are saying that salary is not correct. Salary is not correct. One you are saying. Salary, it is the interim order. Thereafter, final we have to consider the final main appeal only. Why application and all? So we are not deciding that arms our tribunal case is disability or is promotion.
He doesn't want to.
That is, it is not the case.
We take it up, madam, after vacation. Tested matter. We take it up. Tell us again.
She filed an application. In the month of he paid
The circumstances along with the application will consider matter after application. CTM order is a mean for them now. Electing. Now she is out of employment, she say. The main matter itself is decided by the solution. Let them pursue their.
He's the only coming member. What parent? Society not doesn't allow him to for his parents. That is the only and
No, where? No, I mean, where from have you got this idea, Mr.? We hope that you are not appearing before the High Court for the first time. Where from you have got this idea? She's saying something immediately thereafter. You say one sentence. But let her argue. It's her appeal. We are hearing it finally, right? Because we said that let it be after vacation. Both of you are insisting. The only thing is, I will require 1 hour extra. I will stay till 7 o'clock and write a judgment. What is there? Fine. That is what it is, madam. You are coercing us to decide it today itself. We will deliver the judgment right away. What is there? By the time you keep on arguing about maintenance, we are going through the petition memo of judgment to pass by the family court to find out whether ground of cruelty and desertion is made out. You argue on IA, we will decide. We will give you. Cruelty. Hear you, Mr. Is being heard finally. Because you are not telling us, nobody is telling us facts, nothing. We have to write a judgment. We will write a judgment in our way. Let us help ourselves. Please be kind. I mean, fair to the court. We will. It's not that without hearing you, the court will decide. You will get an opportunity. That will be a ground of challenge if it goes against you. So keep all that in this thing. Some ground for SLP also, right? Why are you telling us that? Please correct yourself. Huh? Huh? You are hungry? What? Huh? So, Mr. Please appreciate, this is a petition filed by the husband, being aggrieved by the judgment and decree by which his petition on the ground of cruelty and desertion has been dismissed. On your application under section 24, we have passed an order. And both of you will take longer time than required. In the meanwhile, you are arguing on interlocutory applications, saying one sentence each. We will decide the appeal itself. The section 24 order operates only during the pendency of the appeal. The moment appeal decided, it's not that you are rendered remediless. What is your remedy? Tell us. No. What is your remedy to claim maintenance? Huh? Huh? Please help us, Mr. Amicus. What is the remedy? I wish that we had judges like us in our times. We would have never crossed it. Ask the judge, what should I do? The judge will tell you what is your remedy. Judge will appoint an amicus to tell you what is the remedy. What is your remedy to claim maintenance, Mr.?
The appeal filed
What
by
remedy? What remedy? Not getting it, what we are asking you. What is when an order passed under section 24 of the Hindu Marriage Act operates? No. Give him. Please tell. Micus, please help us. Please read section 24. Aloud. Please, we are entitled to hear what section 24 says. Huh? What is the meaning of that word just now you uttered? What pendency of what? Pendency of a proceeding before the family court or in an appeal. It is listed for final hearing. The moment we decide the appeal, what happens to the interim order? Then if you want to claim maintenance, come to the next section, read section 25. Where is this application, Mr. Application seeking maintenance. Seeking. Reality and evidence.
No. Page 8 is 25/5/2006. Yes. Child is there. 9/2/2012. They were to a female child. Yes.
What is the
8, 11, 12. Then
desertion?
desertion came para 8, 11. Positions of male, during 2008. On left.
The time I think desertion 2008. Marriage,
Yes. No, sir. When a child has born, it says 1 second. A petition not stated in. Okay, again comes for that is nothing. Eighteen 10/2012 sent notice.
application for listing under section. Yes. Listing.
Well, application dated not the 9. So the same. Where.
Is there any application under section 25? Not there. It's an application under section 24. What you have filed. So this order will operate during the pendency of the appeal. If the appeal is decided today, it will cease to operate. Thereafter, take recourse to section 25. Clear? We have given advice free of cost to you. We're at liberty to argue whatever you want to after we are done within our own way so that we are ready to dictate the judgment. Judgment. Oh, judgment. Yes. Not recalling, it is being heard finally. We can madam, this. I've been telling very often that this we can dismiss your application by a single line order, and we want that you test it before Supreme Court. This court had jurisdiction to pass an order. Application for recall lies only when the court has no jurisdiction. You are justified in filing an application seeking review or modification, but recall has a different legal connotation. Recall, review, modification, these are three different connotations. So recall, we will reject. There's no question of recall. We are hearing finally, please argue. We are going to tell you that no orders are necessary to be passed on this IA because appeal itself is finally decided. Please argue. We have found out. Is we will tell you 25/5/2006 married, 9/2/2012 daughter was born, then 19/8/2013 you filed the petition, 2008 according to you she left the matrimonial home, no month, no date, 2008. This what? What recall? The recall. Yes.
Six, 2/6/2009, 2/6/2009, no?
Joined at very easy to he made it. Already by the company given to CDP.
I say that you are now asking for.
She comes back to Mysore. She does not reside with the petitioner with the appellant in Mysore or in Ladakh. She delivers her female child in 2005. She's given a complaint against him. That's what she said. And I think what's most important. Where he was, he did not. He cannot be anywhere. That was entirely different. There is no other much any other language there will be issues. But very distinct personal issues for him. He did not leave the mother. She did not want to join him when the mother. So he very clearly said, I will join you if your mother is. Immediately, for then she in the discussion. Now, where I am. Not to go. He had replied, 8. He came to more than 8. He never turned up to the past. He neglected. He did not want to. He love.
He has asked her to join only when he was on leave. Stated. Please read your notice. After that, my on leave on so and so. Repeated telephone calls, request her to join him, but join means not to Leh or Assam. On leave. Thereafter, he went back, no? In notice, you are not stated that I wanted you to take to Ranchi, Assam, or Leh. That is admitted, no?
Family station. Family stations, they can take. We don't know whether Leh Ladakh is a family station. Maybe it's a family station. Therefore, he should have taken his family there. Leh. How? Leh also children are born, they stay there. Yes.
No, you are saying that we insisted her to join, but she has not joined. That is not the case. So just I wanted to. All right. What he has written, she has written.
Sit down, relax. Sit down, relax. Sit down.
Your turn
Relax.
will come. We'll ask.
We
You can argue whatever you want.
relax. Don't need to be in attention.
Even in exhibit P4, first paragraph, last 3 lines here. Therefore, consider again, my husband left me in Bangalore to take care of myself during the pregnancy and subsequent delivery. He has come and dropped here. Thereafter, he has not turned on me. Reasons he has sent that money is not sent. That is the second paragraph. She says that money is not sent by him. All right.
By the army policemen. 27.5.
All right. This we understood. This you have made attempt for her to take back, but she has not. What you have pleaded in your petition about the cruelty, you read that. Whether it is sufficient to dissolve the marriage. Then as far as this case is concerned, we are concerned only on the 2 grounds: reality and deserts. Maintenance, assume that interim order now it merges with the final order. Which are the paragraphs you want to read? No. Pleading first. You have pleaded. Which are the paragraphs you want to read? Point out those. That is not the pleading. That is not the pleading. That amount into cruelty, you are not pleaded that. In application seeking modification or review or whatever, We can't take note of those things. That may be true. We are not saying that, but it's not there in there. It was not an occasion for the trial court also. Please. That is there. It is in the paper. Well, right. Yes.
Nothing to be so serious about this. The usual run of the mill case for us, right? With several hundreds of petitions, we have decided on the ground of cruelty and desertion. It is our everyday job. It's not that you are asking us to review Keshwanand Bharti's case and to lay down what are the basic features of the Constitution of India. Nothing. We just wanted to tell you that from reading the judgment, we learned that you did not even file an application under Section 24 before the family court. And you are arguing with such passion here. Where will I go? What will I do? That means you did not.
Assets and liabilities you wanted to file.
You did not even file a petition under Section 24. Don't be so serious. That's what you can smile. Nothing will happen. If you smile, it's not that appeal will be allowed. It's not. Relax.
Allowed also, dismiss also. Your rights are intact.
You are so serious. I mean, looking at us as if we are going to cut somebody's neck and something. You are watching like, don't be. Relax. Nothing. You can smile, right? And you realize, you look at yourself in the mirror that when you smile, how nice you look. That we can tell because we are seeing you. So why are you so serious? Nothing is happening, nothing out of the world. Just like any petition on the ground of desertion, nothing will happen. Nothing happens to your career as an advocate. Nothing happens, irrespective of the result of this appeal. Why be so serious? Sit down. Relax. Nothing. Even if it is allowed or dismissed, nothing, you are not going to stay with your husband. We know that. Yes. Yes. Please go ahead. Yes.
No, but in para 16, birth of the child. So that this is superseded by. In 2012 to 2013, you have filed petition. Desertion goes. Cruelty also nothing.
Secondly, with public. Also, right, each point is clear. What's.
To 10 to 12. Legal notice from he says 2008, 2012, he admits that he is delivered. Change file.
Something came to a childhood bond.
No, 2012.
Very childhood.
Yes. Yes. Page number, page number.
Not agreeable for.
So she has not stated anywhere that I will not go back to the Ranchi or Leh ಅಂತ ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ. She says that I am not ready to stay with her mother.
They are all raised. Nothing is not right. Other are nobody evidence.
That issue, we will not decide those applications. We are deciding it finally now. It's a settlement. We can't say ask. Yes. Two lines. Final argument. You are constantly speaking on IA, and there you have nothing to argue.
I am fighting, I thought.
You were
We were
fighting.
fighting.
That's why
Application.
both of you were fighting. That's why we are constrained to write a judgment. Ideally speaking, I would have preferred to write it beyond vacation, but because you were fighting, both of you, we decided this is the argument. Two lines.
We don't want any submission. You want to argue? No, you try to understand. She has argued something. She has shown the documents. She has asked her to read the petition. She has read the petition. You don't want only two sentences on that if you allow the petition. What you will answer to your client?
Yes. Go to argue on
On the
section.
application.
To
Think that
argue
after
on
this also you will argue the application. No, I want to have, sir, we wanted to continue tomorrow. We can.
You are not prepared, right? The case. Learn it. Mrs. B.V. Vistulata, council has concluded her submission. Current council for respondent, write his name, praise for short accommodation. Is what will enable him to prepare the case on merits and argue the same. Not on IA, right? List for
No, don't write like
list for further hearing. Tomorrow. Further hearing. It will come by 11 o'clock or 11:30. We don't know.
make a list kind of synopsis. Or allegations, how it is dealt. Evidence is. Let him argue.
Tomorrow we do facing this one and the other one. It is called. Oh, after vacation. Oh. Huh? And
There.
for the appellant, Mr. M.S. Rajan, learned counsel for respondent. Line below, list after ensuing summer vacation. Adjournment, right? Adjournment. Huh? Why?
Tomorrow. There yesterday, no?
Your madam application for early hearing has been allowed and you don't remain present. What is this?
Her request, you have not heard, sir. She is asking for pass for now.
What
She is
will you-
coming, I have to wait.
Learn it on. No. Learn it counsel for the petitioner. Praise for adjournment. What is your name? Whatever. Write her name for adjournment on the ground that arguing counsel, Mr.
Okay, Sheshwini.
Mrs. Miss Yashaswini is out of station. Is held up. This is no ground for adjournment. Held up order 17. You read the ground that the council is not arguing counsel so and so available on account of personal difficulty. The writ petition was listed for final hearing on the application for early hearing filed by the petitioner himself or petitioner himself, herself. However, the counsel for the petitioner is not free to argue the matter. In these circumstances, of course, hearing is deferred list after ensuing summer vacation.
It is discharged. They are not serious.
They are not
There is change
serious
in the
in
this thing, you know,
prosecuting.
OBC category.
Yesterday it was called. She didn't
Order sheet,
appear.
please show.
Today at 4. If it would have been there, she would not have appeared before single bench.
Yesterday
It's
she was
all-
not there.
I mean,
You
this
know,
is
you know,
all,
you know.
we should impose cost on them. Why? What option we could? This all, there is nothing in the petition. We should have dismissed. Yesterday also, madam, you didn't appear. Your application for early hearing has been allowed. And the adjournment is being sought by your this thing, colleague. No, single bench is more important, right? Then why did you file an application for early hearing? Perhaps we should not have allowed it. And we should have rejected it. And we should have made you to run to Supreme Court. What is this? But is there any justification for filing an application for early hearing, we are granting it and then not arguing the case. It will go after vacation. No. No, ready for argument, then the court should be ready to deliver judgment, right? Any case as per your convenience, say I am ready to argue. Why you did not last date also it was adjourned. We remember.
You are not
madam.
there. You are not present.
Not present.
Yesterday only. No? You are not there.
Then
You are not there. Madam.
not
Yesterday.
see several times it has been. We remember. Give it. Side. See. That 30th March 23, you sought adjournment to produce the rules. Why have we allowed this application for early hearing? This is a 23 petition. Has been issued. Why it has been allowed? Petition, Mr. Award. Will write judgment. Day after tomorrow, everybody will be able to, they are ready to argue at 1 p.m. that I am ready. The court has to take care.
Application. Can grant liberty.
Will grant you the liberty to move the vacation court, madam. Everything can't be thrown at our head at the
When
11th
we have
hour.
called the matter, you are not there. Your colleague appears and says.
30th
that-
March. Then 4:25, she is seeking a passport. What can? No, we will permit you to argue in vacation.
When you will complete your argument, he has to argue. Then we have right judgment.
Like we should carry the judgment on our head. You will be done by saying something. This is a change of category, not permissible under rules. Change of category not permissible under rules, right? Simple. She had applied under the general category, subsequently change of heart and mind. So the rules do not contemplate change. Objections have been filed.
No, my lord.
Who was filed? Respond number 1. Dental counsel.
5 and 9.
Yes, madam. Why did you fill up general category? No, can you rectify any time? Which under which provision that tell us which rule permit that once you have disclosed your category as general, thereafter you can say anything. No, I belong to scheduled tribe. Why you did not fight? This is the way, madam. Of documents, I'm really confused. From all documents are filed in the filing section. They are never handed over to judges like this across the table, reducing it to Mayo Hall court unit, where you give this thing documents like to judges. He writes the order sheet. Anything. One side argument is going on, another side. This is what you want in the High Court. Why have you not filed it? Why have you not produced?
30th March was the last day.
31st. 30th March. Today is what date? 19th. What prevented you from not filing documents for long weeks?
Vacation will permit her to move vacation.
You move, madam. You file these documents and
We'll
move
say
the
that you are
vacation
seeking
bench.
time to file that memo and permit us to move the vacation bench in view of the urgency.
Learned counsel for the many purposes of that bench will not grant relief. So,
But
learned-
whether they have case, if it is there, you should inform the vacation bench. Make some
No,
kind of
no.
synopsis. You will not be able to tell that. It is permissible or not regulation. We don't know anything. We have to put a question to her and then she will not appear one day. She will come another day and say something. Now we don't have any time in vacation.
No,
If you
any provision in the rules which permit change of, then what submission you were making in candidate's favor? You said. Huh? Where is that Madras site? So you can cite it before vacation bench. And you supply her a copy so that she can cite. Supply her a copy so that she can cite. The judgment pattern.
file along with that also.
Learned counsel for the petitioner prays for short accommodation to enable her to file a memo for production of documents as well as to go through the judgment dated 4/7/2019 passed in
Write and give.
by Division Bench of High Court of Madras. By learned delete place for adjournment to enable her to file memo of documents. Line below, learned counsel for the petition granted liberty to mention the matter during vacation. For the parties even and for the appellant even when the matter is called in second round, write her name, learned additional comment advocate correspondence 1 to 4 awaiting appearance of learned counsel. The appellant hearing is deferred list after ensuing summer vacation. None for the petitioner even when matter is called in second round. Mr. Hegde, learned SPP2 just in the next week. Next week. We have said next week. Whenever there will be 2 days, or it will be listed on one of these. What we don't know. That's why he is not here. But that is Mr. Hegde, that's a serious issue.
Another matter.
We understand it has an impact on this thing. Please examine it very well. See, whatever, please, assist us properly. That's what we are trying to tell you. Assist us properly because that has ramifications, right? Prima facie, it appears to be what he has contended is without jurisdiction. Please find out.
No,